in Parliament.
Yeah.
And my other friend, quite correctly, didn't want me to show you anything concerning that communication yesterday. So, but it is my humble submission that where there is a benefit, then there is actually no need for consultation. Where there is no benefit or there's adverse effect, that is one that you would expect, then there would be a consultation. Perhaps, if I could just perhaps wind it up. Though I know that it introduces what I thought was controversial, I didn't want to come to this now. But let me do it here so that then I'll go to the prayers and then I finish thereafter. I submit my lords and lady that the issue of prorogation and the issue of the de jure declaration of emergency under Section 23, those are two separate regimes under the Constitution. Now, it is my humble submission that both are intended to achieve the same objective of preventing the spread of the pandemic, and it is my humble submission that whereas you cannot use one as a yardstick to measure the reasonableness of the other, it is my humble submission that the common denominator thereof is that it is intended to prevent the spread of the virus. Now, it is my humble submission. Sorry, my lord. Just wanted to
do I understand you to be submitting that the emergency powers serve the same purpose that the prorogation serves?
Yes, under different regimes, yes, under different regimes.
You know, for purposes of containment of COVID-19,
yes.
Are you saying, submitting that the emergency powers under 23 serve the same purpose as prorogation does?
They potentially
for purposes of containment of COVID-19?
Yes, they potentially serve the same purpose. I said potentially.
Oh, potentially.
Yes, potentially serve the same purpose. But I am not saying, my lords and ladies, that
yeah.
When the issue of the exercise or the involvement of His Majesty is looked into, those two regimes are both important and relevant.
But if that is the case, we know that Cabinet made a decision that a state of emergency should be declared.
Yes.
Was that not sufficient? So that the PM should not have then, after deciding at Cabinet level that emergency should be declared, then to go to His Majesty alone and then say, well, Your Majesty, can you proceed to close down Parliament? I know you said it's controversial. Yes, yeah.
Let me just first of all say, my lord, that the limiting tests is that which I read to you from the DA.
Yeah.
What you call a judge. And we have to have that at the back of our minds when we deal with the matter. Now, and your Lordship presiding, as I indicated, asks the issue concerning the element of the parity between the three arms of state. And it is my humble submission that the same argument which your Lordship had raised with me concerning whether, the cabinet and the executive could simply close down another branch of government, the same issues would arise. Now, it now thrusts us back to the same argument that what the methods that have been chosen, is it rational? Is there any rational connection between it and the powers as conferred. I submit, my lord, that then we would be caught up in a situation where we are now moving around in circles. This is why I submitted that we should not use one of the regimes as a yardstick as a measure of reasonableness of the other. And advisedly so, because then the same questions would arise. Whether it's done purely by the executive decision, or it's done under the machinery of prorogation under section 91.3, as in this case.
A question has to be asked, Mr. Taylor. If the Prime Minister sitting at cabinet level collectively took a decision with his cabinet colleagues that an emergency would be sufficient to contain the virus, declaration of emergency would be sufficient to contain the virus. What was the need for the Prime Minister then to augment that strategy by resorting to prorogation? I know I'm asking the question differently now.
Yes.
I did ask it earlier, but the question would be, we now know that they decided at cabinet level, all of them,
yes,
that the way forward is to declare state of emergency. And we know that I think we can take judicial notice of the fact that their colleague, the Minister of Health, was then mandated to come with a regime of regulations, which are regulating actually the lockdown.
If I could just inquire from His Lordship, is your Lordship reading this from Annex A1 at page 82 that the cabinet decision was that this number would be sufficient, or is your Lordship inferring that the steps that are set out therein would be sufficient?
Yes, together with that, because as I read that, it would mean that if the PM was minded to go and advise His Majesty that prorogation would have to be part of the emergency regime, as it were, because it doesn't work separately, isn't it, as I understand it? It's part and parcel of the emergency strategy. That is prorogation. And that prorogation was never debated at cabinet level. Not that it would have been improper for cabinet to debate it.
Yes.
Because the Prime Minister could well have said, as you know, colleagues, I have Section 83 powers,
Yes,
to even advise His Majesty in the matter, insofar as Parliament is concerned. Because it seems Parliament is the only arm of the state which is problematic here, isn't it? Because there are too many of them sitting there.
yes.
But in government and in the judiciary, it seems the numbers are not a worry.
No, I understand,
Yeah.
my lord. Unless I didn't read it carefully enough, the annexure A1 at page 82 doesn't purport to be an exhaustive modality for the combat of the virus. That's number one. Number two, my lord, the issue of consultation.
Or I suppose you are saying it doesn't bind Parliament.
It doesn't bind Parliament. This is why I was saying your Lordship would have raised the same question in relation to the executive decision being, locking down without Parliament. The same question that I'm being asked now would still be asked.
So if it doesn't bind Parliament, it means the 50 persons assembly rule was actually geared towards applying in respect of these institutions that are mentioned herein only. That is you have funerals, weddings, And
Oh, your Lordship is looking at the regulations.
no, A1,
A1 at what page?
page 82.
82.
The cabinet's decision, isn't it?
No, I have it. I'm just simply saying the paragraph from which your Lordship is reading.
Paragraph 2, Roman 2.
Roman
You
2.
see funerals, weddings, and other social gatherings
Para
of
2, Roman 2.
festivities. That is A. Then you go to B. You have tertiary institutions. That is the schools in all their respective hierarchies. Suspension of sporting activities.
Yes.
Visits to correctional services. Non-essential travel. Management of institutions, the public, private, and civil society sectors.
The advisory?
Yes, and then the border controls, well, nationals of Lesotho living abroad.
Yes.
So it means that's what Cabinet was only worried about when it came to the operationalization of the 50 persons assembly rule.
Yes, now, but there was another sector of the society. There was another institution. And the only person who held the key in respect to that institution, in furtherance of the same objective, was the Prime Minister under 83. Now
that I understand, and I'm saying if he had that in mind, sitting at Cabinet and chairing Cabinet, wouldn't it be fair and reasonable for him to have said, sitting as the executive, we are making decisions that affect only the institutions of government in the executive and, of course, in the public and private sector.
No, my lord,
so that if there's a need for any other arm of the state to come along and play the game, shouldn't a similar opportunity have perhaps been accorded to these institutions themselves to say, well, Cabinet has already taken a view in respect of this matter,
yes,
knowing that this decision doesn't bind Parliament or the judiciary because of separation of powers?
I again answer the question, and this time I must maintain my position as a lawyer now.
Yeah.
That question arises only to the extent that it affects the question of the validity of the prorogation. And it is my humble submission that it does not. While it may have been, politically expedient or even collegial for him to have done so, but I submit that insofar as the question of prorogation, which we are concerned about, that does not.
Assembly.
It is that not
that he the fact that we are approaching His Majesty to advise him to prorogue Parliament, and even when they get there, the subject of prorogation is broached for the first time. Hence, then the meeting had to collapse because the quartet disagreed amongst itself.
That is what I was going to say. I was going to deal with the fact that my Lord and Lady will remember that the version of the first and second respondents is very clear.
Yeah.
It's very clear that there was consultation with these partners. There had been consultation with these partners. There was no cloak and dagger approach of the matter, insofar as they are concerned. Which they, in other words...
That is for purposes of the meeting at the Royal Palace.
Yes, yes. That there were prior discussions, they were told about this, and there was an engagement with them about these things. And then they went there, and then there was a disagreement.
So it was a matter of courtesy by the Prime Minister to them, to call them to ask them to accompany him,
yes,
to the palace for him to tender the advice. Is that what you are arguing? That they were, courtesy were extended to them. Come along, gentlemen and lady. I'm going to advise His Majesty. Come along, so that you are there when I tender the advice. And when he gets that is the Prime Minister, that, well, they are saying, no, we disagree. Meeting has to come to an end on that account.
Yes. There's something that I want to consult on, whether I'm given permission to talk about it, but let me just consult. Yes, my lords and lady, I'm cautioned against going into the details of how this arrangement happens to be that he would be bringing, the coalition partners before His Majesty.
No, I'm merely saying, is it not common cause on the papers that that's what happened?
No, it's not common cause. What
I'm saying, what happened is that the Prime Minister goes to the palace.
With them?
Yes.
Yes.
Is that not common cause?
No, it's common cause that they went together.
Yes, that's what I'm saying.
Yes.
That's why I said the Prime Minister invites them to a meeting where he's going to tender advice, or is the dispute, or are you saying we shouldn't know whether the purpose of going to the palace?
No.
We should know that.
No, you know. We have not shied away from that. We have actually explained that we had gone there to advise and did advise, but the advice was followed later by the written advice. It was tendered verbally at that meeting, and later followed by ABC1. That you know, and we have no problem with having
I thought that you had a problem in answering what I was putting to you earlier after consulting.
No. Here is where the problem lies.
Yes.
Your Lordship wanted to make an inference from the fact that he went there with them.
No. With them, I'm merely saying they were there together. We know that the sequence of they are going there, is this. That they say they found him there with his deputy.
Yes.
That is Chief Masiribana, yes, and Miss Ransu.
Yes.
They say, no, we didn't even know what was going to be transacted there, because we were not given any notice.
Yes.
You see.
But
I know that the version of your clients is that, no, they knew.
Yes.
That we were going to tender advice.
Yes.
You see. But the bottom line is that at that meeting, there was a disagreement.
That's correct.
Yes.
That is correct.
And that disagreement could only have been about the issue of prorogation.
Yes.
That's not a secret.
No, it's not a secret.
And we know that.
Yes.
So that is common cause.
Yes.
So it is in that context that I was putting my my question to you earlier, before you took instructions.
Okay. But what was the inference that your lordship wanted to draw therefrom? Because that was the instructions that I was taking. Because, you know, there was an inference that your lordship wanted to draw. But that inference would be, you know, possible, but not the accurate one. Because,
or not the only one.
Or not the only one. So this is why I was taking instructions.
But no, I'm merely saying.
So I was simply trying to find out whether I can take instructions. I can divulge, but it would seem that it.
No, I'm not saying you should divulge.
Yes.
What was discussed there?
Yes, it's a possible inference.
Yeah, but we know that from the affidavits of your client,
yes,
that is the Prime Minister,
yes,
supported by his deputy.
That's correct.
That we went there, and that was the purpose of going there.
That's correct.
Yeah. But then the applicants are saying that's why we disagreed.
No.
And the meeting had to collapse.
No, not when we disagreed. Remember that Chief Masriban and Minister Ramto are not applicants. That's why the coalition partners then say there was a disagreement. Yes.
Does it make any difference, Mr.?
There is a difference. No, there is a difference.
Or are you saying they went there in their capacity as the quartet?
Yes.
In the coalition, not as not as ministers of the crown, because we have to then draw this.
They went with the dual capacity of ministers of the crown as well as the quartet.
Yes.
Yes.
So whatever they transacted as a quartet,
yes,
they transacted as ministers of the crown, and vice versa.
Yes, but I was just worried that your lordship was saying, and then the applicants then they disagreed. Well, the disagreement was between the quartet and, you know, between themselves, not the applicants.
Or the quartet.
The quartet itself.
Not the applicants.
Not the applicants.
Yes.
Okay.
But I'm saying the applicants are saying that's what happened.
Yes.
Yes.
No, my lord. The correct one is that the chief Masriban and Gegezoransu, Minister Gegezoransu say so. Well, I agree that it's the applicant.
And that's part of the evidence that is put before us by the applicants. Yes.
My lord.
Yes, you can proceed, please.
I want to then gravitate towards the finish, and when I do so, I ask that we refer to the record at page 3. I'm going to start from the end, moving backwards. That is the end of the notice of motion. I want to deal with these prayers one by one, but very briefly also. Prayer 4, my lords and lady, is that His Majesty and Head of State cause the dismissal of the outgoing Prime Minister, first respondent, and new Prime Minister be appointed in line with the prescripts of the Constitution of the Kingdom of Lesotho 1993. I just want to say one thing and one thing alone, that there is no basis for this prayer. I ask that it will be dismissed. And then we go to prayer 3. It be declared that the outgoing Prime Minister is no longer a fit and proper person to hold, no longer fit and proper to hold the office of Prime Minister of the Kingdom. It's the same thing as 4. It's substantially the same, and I ask that there's no substance therein, and it should be dismissed. Then we go to prayer 2.8.
Does it matter, Mr. Taylor?
Yes.
That is referred to as the outgoing Prime Minister.
Well,
because if he's outgoing, would there be any need to do anything about it? Does it matter? Or should we take it that no, the reference to outgoing is of no moment?
Well, it's only of moment to the extent that it's derogatory. It's intended to be derogatory. If you look at the entire affidavit, you'll find that it's intended to be derogatory.
No, I'm saying, was it not pleaded in the context that he's leaving? Is it not common cause that he's leaving?
No, but you don't say a judge who's sitting, I'm sorry to make the example, who's retiring and say retiring justice bad, retiring justice for me. We don't say such things. I mean, those are derogatory and they're so intended. Anyway,
maybe the problem is that in politics there'll be outgoing and incoming. I suppose that maybe that's where the problem might be.
No,
but in any event, I'm saying,
yes.
If assuming that, would it have been proper, assuming that we were with the applicants on 4, to say His Majesty is directed to dismiss the outgoing Prime Minister?
No, it's okay.
If someone is outgoing, why is there even a need to, unless you are saying expedite his outgoing?
Yes. I don't want to, Your Worship, with respect, I don't want to glorify this, less than flattering prayer with a response. It is meaningless. It cannot be granted. It's not sustainable from any angle whatsoever. It need not even be discussed, I submit with respect. Both prayer 4 and 3. I was dealing with 2.8. It says that...
Is it prayer 2.8?
Yes, my Lord.
Yes.
That it be declared that the outgoing Prime Minister, first respondent, does not have constitutional authority to advise or recommend to His Majesty the King and Head of State that Parliament should be prorogued at the time and duration prescribed by law for the duration chosen without singly or collectively the engagement of the coalition partners and the executive. I think I've dealt with this in my heads of arguments. I've also dealt with it during the process. I submit that these are not prerequisites for the exercise of the powers of the Prime Minister or the duties of the Prime Minister under Section 83.
But aren't they suggesting duress? Aren't they raising duress? Maybe what he did was outer duress.
Ultra virus in relation to the failure to consult, or ultra virus.
Yes, in relation to failure to engage or to consult or whatever.
Yes, that is what they are saying. Yes, that is what they are saying, and I'm saying the legal principles are very clear. As far as cabinet is concerned, we refer to the case of the Attorney General versus His Majesty. As far as it would be remarkable if it were that now the engagement would be in respect of coalition partners. But I have referred to the question of agreements, the effect of agreements of this nature, that they would not in any event fetter the ability or the ability of the Prime Minister to proceed. Remembering, of course, that cannot be decided purely on a pure legal matter. It is also a factual matter, whereas the papers stand, there's a dispute of fact where the respondents are saying I had consulted. There had been consultation on a individual basis. Now, I would submit then that, as I said, the pluscon events pains rule applies in relation.
So you're saying
that it and talk about the His Majesty.
What people? If we grant it, what purpose would it serve?
It serves no purpose, none whatsoever, I submit. It's an academic thing and caused on
Yeah.
It be declared that the collusion of Parliament and actual publication of the decision of the Government Gazette without the unanimous consent of the coalition partners is unconstitutional and unlawful. It is the same prayer, well, unless I don't understand how it's couched, it's the same prayer as 2.8a. And the submissions I've made there in relation to okay.
I caught my that for my clients you are handling the issue of the 2.5 solution.
You hadn't considered earlier?
Yes, I had not considered it
Okay.
yet.
All right.
On my short reflection, I have considered the prayer 6 months.
Okay.
All of us.
Okay.
On short reflection.
So on that one, then Mr. Taylor need not worry. 2.5.
By all means.
Just as I'm not worried with the rest of them, with respect. Now, my Lord and Lady, then 2.4. Uh, 2.4 and 2.3 are couched in a manner that it's likely to cause confusion. But I read the papers over and over and tried to understand the distinction. As far as 2.4 is concerned, it would appear that the draftsperson was looking at what was drawing a conclusion from what is set out in page 17 of the record. Page 17 of the record, paragraph 5.14. There, the paragraph reads, the impugned legal notice number 21 of 2020 is ex facie irregular and or unconstitutional because prorogation of Parliament in the Kingdom of Lesotho cannot be effected via section 91.3 as it has been purportedly done, but rather in terms of section 83. The instrument is therefore pro non scripto and hence not enforceable. The purported prorogation of Parliament has not taken place as purported or at all. The purported exercise of constitutional powers proroguing Parliament as borne out by legal notice number 21 of 2020 is a nullity and false to be rejected. I mean no disrespect to the drafters of the application, but it would then defeat the first prayer, because if you say
the first prayer being 2.3.
Yes, that the reason to prorogue Parliament pursuant to the provision of section 91.3 be reviewed and set aside. Because if they were to be correct in terms of the argument set out in 514, what that means then is that there is no prorogation to be reviewed and set aside. But then perhaps it would have been put in the alternative, but I think maybe under the pressure of time they did not consider that. However, I want to submit very briefly that insofar as this matter is concerned, that if it is a citation, if they allege that the prorogation notice or notice, yes, cites the wrong section, which we do not concede, that does not mean that it becomes invalid on that account. I submit that where there is power, what is power conferred in the law, and the functionary exercises the power but misquotes the section, that does not mean that then the power has not been properly exercised, so long as the power is there and available.
But isn't it being suggested here, Mr. Taylor, that
at 514?
Yes, that the ex facie irregularity and the proposition that the Gazette is pro non scripto and not enforceable is actually is said in the context that the Prime Minister has no business exercising Section 83 powers via 91.3. Is it not what they are saying there?
Does it come out clearly? But I'm prepared to assume anything that it suggests that they are saying, which they have not said.
No, I'm saying they say the impugned Gazette
Yes.
is irregular and constitutional because of the manner in which the prorogation.
No, but it then says, it cannot be effected via the cited section 91.3.
Yeah.
But it can only be done under 83.
Yeah.
Now,
In other words, they are saying the Prime Minister has no powers to prorogue Parliament. It is only the King under 83. And for that reason, then the Gazette issued by the Prime Minister is irregular and unconstitutional.
I'm prepared to run along with that, but that is not how I read it.
Yeah.
How I read it is that the section that authorizes the publication prorogation is 83, not 91.3. But I'm prepared to run along with it and say, well, let me start first. Notation of the powers under 90 to section 83. So I submit that a misquotation itself would not be sufficient to set at naught the exercise. But now I can go further then to address the second aspect of the other aspect in which the Lordship understands it, and simply say that it cannot be. There is no doubt. There is no doubt that in terms of Section 91, subsection 3, that the Prime Minister has the default powers to exercise the powers of His Majesty in certain circumstances. Now, then it would have led to the misreading and the misunderstanding, I submit, of the proper meaning of Section 91, subsection 3.
But that's what they are saying. You say it's improper. They are saying it's proper.
No, let's
understand what you are saying, that would be, but they are saying that is proper. In other words, they are saying 91.3
yes.
cannot effect 83.
Well, it can affect every other section.
Shortly stated,
Yes.
prorogation
Yes.
is the power of His Majesty and His Majesty alone.
Yes.
That's what they are saying.
Yes,
so that no other person can even issue a gazette in that respect.
that is baseless, I submit.
Yeah.
This Constitution is clear. It's very clear as to what happens, that the Prime Minister may overreach His Majesty. And I submit that if that is what it means, I submit that it cannot be sustained. The last prayer, but the first, that is in the order in which I'm dealing with, but being the first on the papers.
That is 2.3.
2.3, my lords. Yes. Now I submit that is the prayer that you my lords and lady, will have to go and consider. And I submit that what has been put before you by the first respondent and the second respondent in this matter, or for the respondent in this matter, in the light thereof, you should find that prayer is not sustainable, and it should be dismissed.
Yes.
My lord and lady, I go back to the end on the issue of costs. I have instructions to ask the court to adhere to the by-watch principle as adopted in this jurisdiction regarding the matter of costs. It is true. It is true.
Can you restate it again?
My instructions are that you
Principle.
or restate the principle.
Yeah.
Yes, the principle is that in constitutional matters, costs are not normally awarded. The intention being not to deter parties from, coming to court to assert their rights under the Constitution, but only to the extent, can only be granted costs or marketed costs to the extent that there's misconduct on the part of the party, which would be an exception. Now, there would be misconduct here, but I don't want to talk about it. In the language.
Isn't the principle
yes.
for the benefit of private litigants?
The private, yes.
Not the state.
No, not the state.
So that if a private litigant wins, the state will still be enjoined to pay the cost.
Yes, there's the private litigants, yes.
Yeah.
Yes, I'm talking about
so that in council here, if they succeed,
yes,
the Crown would have to pay their costs.
This is why I said in relation to them. This is why I'm saying we are not asking for cost. That's the instruction on the basis of the principle, because it applies in relation to them.
Okay.
Yes, I'm not saying we want costs. And I want to conclude, my lords and lady. This honorable court will, as it should, have to apply its mind to the real danger that exists posed by the coronavirus. It is my humble submission that whatever is said in the papers and everything else, at the end of the day, the court will take into account the fact that we are dealing with a very monstrous disease that could very well cause problems for this nation. So that will be at the back of the mind of the court. Not that it should not treat the principles of law as it should, but I submit that it will deal with the matter with the sensitivity that the matter deserves in the context of what we are experiencing at the present moment. Unless there are further questions, I am done.
May I ask Mr. Taylor, I know this might be difficult to answer.
Yes.
COVID-19 is a threat to all societies.
That's true.
And all societies seem to take the cue from WHO in adopting strategies to combat it.
Yes.
Apart from prorogation of parliament in this kingdom, would you be aware of any other state which has prorogued its parliament?
I'm even aware.
For this reason.
I'm even aware that in Hungary, they've actually dissolved themselves and bestowed upon the Prime Minister the power to run the state on an emergency basis.
But that's voluntary. If you say they bestow, they do themselves. But
no,
I'm saying the prorogation in the context that the parliament itself, is confronted with a fait accompli.
No.
But where parliament decides we are surrendering voluntarily our powers to the prime minister or whoever or the king, That I understand. I'm merely saying prorogation in our context,
No,
where it's non-negotiable.
Well, if you
And Parliament is not consultant, it's non-negotiable.
well, to answer it, my lord, I'll simply say I've not looked around.
Okay.
I will look around.
Okay.
But it doesn't derogate from the submissions that I've made that in any event that is the best method thought to be effective in relation to this matter.
Okay.
That's a call, please.
Yes, Mr. Ndebele, is there anything in reply? Sorry? Or there's something to reply to?
The first one, my lord, is in relation to the judgment of the Miller case. And I simply wanted to add the following, to say, in that case, if their lordships will look at it, there were two grounds upon which the court was called upon to determine the lawfulness or otherwise of the prorogation. The first one appears at paragraph 55. And the court asked a question. And it says, the first question, therefore, is whether the Prime Minister's actions had the effect of frustrating or preventing the constitutional role of Parliament in holding the government accountable. And if you read through, then the court had to interrogate facts in order to answer that question. Then, if you go to 58, and once at 55, in order to answer that question, the issue of motives plays a role. Now, going to 58, the court now brings in the second question for determination. Second issue for determination, and it says, the next question is whether there is reasonable justification for action which had such an extreme effect upon fundamentals of our democracy. Most importantly, the court says, in determining and answering this particular question, at least in determining this particular question, we are not interested in motives in answering that particular question. It says we are only interested in a reason. And I would call upon the court to adopt the similar approach.
And those reasons are in ABC 1, Mr. Ndebele.
Those reasons are in ABC 1.
Yeah.
We don't have an issue. The issue that I had was when the court said motives are irrelevant. My submission is motives are irrelevant to answer this particular question. But to answer the first question, they are relevant. That would be my first submission.
So we should, motives are relevant to answer.
In answering the first question.
At paragraph 55.
At paragraph 55.
Why would motives be relevant there? Is it not an invariable consequence of prorogation that it would have a deleterious effect of frustrating and preventing the constitutional role of Parliament?
If,
Is it not, it comes with the territory, isn't it, Mr. Ndebe?
my lord, if that is,
So we
that is
need
the
not even ask any motive. We are saying these are the casualties of prorogation.
if my lord, reading the facts and analyzing,
Because otherwise you are bringing through the back door. You want us to do indirectly what 58 says we should not do.
no, my lord.
Yeah, because once you say motive is relevant here, it means then what is said in 58, you are saying we should do exactly what 58 says we should not do.
58 does not prevent the answering of the first one. We are addressing each ground here, and each ground is addressed differently and with different facts.
Did the Prime Minister, in his reasons, advance what he stated in 58, that I'm doing this to frustrate Parliament?
He wouldn't dare say that.
That's the point. That's what I'm saying. It comes with the territory. There's no issue as to whether motive applies there.
Please understand me, my lord. In order to answer the first question, the motives are relevant. You cannot answer that question without referring to motives.
No, but then it goes against what 55 says.
It doesn't.
Because the legal principle as stated in this authority, it's very clear that those, whether in fact, factually, this is what would have ensued if Parliament was prorogued.
My lord, may I say?
Otherwise, you are saying no. The Prime Minister had a motive.
We said so.
But
in so many ways.
the issue is that when we have to examine the legal justifiability of his reasons.
Yes, that is the question. That is the second leg to answer.
Where does the court say in that paragraph? Where does it say motive is relevant?
In this paragraph?
Yes, where does it say that?
It does not specifically say that.
It doesn't say that.
But in answering this question, then motives are relevant.
No, but I'm saying the court doesn't say that.
It doesn't say that.
Yeah, so why do you say we should say that if the authority you are relying on doesn't say that?
It doesn't say so expressly, my lord. But in
even implicitly, it doesn't say that.
Yes.
Even implicitly.
No, I'll submit it says so.
Where does it? What do you say? Where do I get that
in giving answers to this particular question, we will have to rely on motives as we submitted.
Can I ask you, is there any prorogation which does not have the effect of frustrating the constitutional role of Parliament? Will there be a prorogation which doesn't do that?
Every prorogation does that. But if
that's why I said it comes with the territory.
If that is the only object on the part of the Prime Minister to frustrate the business, then it is unlawful.
But we have to look at the reasons.
That is the second leg.
No, but did the Prime Minister in ABC 1 said, I'm advising His Majesty to prorogue this Parliament so that I can frustrate it?
My lord, we have submitted facts. Unless our facts, the facts submitted by our clients are not considered.
Which fact is that?
We have made an allegation that there is a bill in Parliament that deals with cutting off the powers of the Prime Minister.
No, but all those things are irrelevant, Mr. Ndebele, because those are consequences of prorogation. Now you are saying we should consider consequences and then go back to say, because there are these consequences, what the Prime Minister had in mind was actually to do that.
There is no way you can answer the first question without going through that and accepting that as a fact.
Is there any other authority to the same effect? Maybe the one that explicitly supports what you are saying.
No, my lord.
Because this one, you are saying it implicitly supports what you are saying.
We are relying on authority, my lord, it is instructive.
That's why I asked you, is there any authority anywhere in the world where prorogation does not do exactly what is stated in paragraph 55? Otherwise, it will not be prorogation. It's not prorogation, it's something else if it doesn't frustrate or prevent Parliament from performing its constitutional role. It's something else.
We are going to provide the book written by Professor Anna Tome. He cites several occasions where the Parliament was prorogued for purposes of frustrating the business of Parliament. And she says that was unlawful.
Where does he get that? In those authorities, was there not evidence that the Prime Minister actually said, recommended prorogation precisely and explicitly to frustrate Parliament?
My lord, the Prime Minister would never say that.
If he hasn't said it, where do you get it that he
when you
said
read
that?
the facts, when you analyze the events, the conclusion that you
The
only
problem
come
that is reverse reasoning. You look at the effect and say, because this is the effect, then we must say the Prime Minister intended that. We shouldn't engage in reverse reasoning, isn't it?
My lord, we shall supply this book to the court.
You said that when you started addressing us that you are going to give us that book.
Yes.
You told
And
us.
His
what
Lordship
you
will have time to apply his mind on this particular
Yes.
issue. And
said. What's the next point?
the next point, my lord, would be the application of the Oster clause. My lord, we need to read that clause and find the true purpose of that clause. I submit that where the Prime Minister has advised His Majesty to act in terms of Section 87, and prorogation is accepted.
Section 83.
Section 83, yes, my apologies. Section 83, and prorogation is accepted. Then provisions of Section 91(5) will apply to protect His Majesty. And I submit, my lord, that the Oster clause is actually meant to protect His Majesty, because it is assumed that when he acts according to the proper advice, he acted lawfully, and the responsibility now is upon the advisor and the cabinet to account to the Parliament. That is why a question cannot be brought whether he received and acted upon the advice.
Is that an issue before this court?
The issue, my lord, that was brought is that
You are not complaining about 83. That's what my brother is
No, I'm
is
telling-
asking. He's saying, should we bother about 83? Or should we bother about 91(3)?
he also mentioned Section 91(5). Now, my submission now is, when the Prime Minister acts in terms of Section 91(3), he is not covered by provisions of Section 91(5). Because by the very provisions of that section, he must account to Parliament.
Justin, does the issue of the ouster clause really apply in these proceedings? Given that we know that...
It was raised, my lord. I'm responding.
We know that the Prime Minister acted in terms of 91(3). And once he acts in terms of that section, we know that His Majesty failed to accede to his request. So does it even arise in these proceedings? Are we not wasting our time on this?
They claim executive privilege, my lord. They claim executive privilege in terms of Section 91(5).
No,
And we are saying it's not.
No, Mr. Ndebele, you don't understand. That claim of executive privilege is in relation to the documents. To the documents. There's a difference between executive privilege and an outside clause. So let's not confuse the two. Where are you at? Are you at the outside clause or are you at executive privilege?
I was at an outside clause, my lord, at the moment, because they also refer to it. Yeah. And it was said, whatever that has happened cannot be questioned.
But my brother is saying, since the issue is not whether or not His Majesty was advised or was not advised, acted or not, did not act. He said that question is not before us. What is before us is whether or not the Prime Minister
acted lawfully,
acted constitutionally by invoking those 93(1) powers.
That is an issue, my lord.
Yeah, that's an issue.
That is an issue.
Yeah, what do you then say about that issue?
That is an issue, my lord.
What do you say about that issue?
My lord, regarding that issue, I listened carefully to the submissions made by our learned friend in the detail.
No, Mr. Dele, not in Tate. He's your learned friend.
Yes,
not in Tate, isn't it? He might be in Tate outside. Let's not forget, I don't mean any disrespect for sometimes we forget in a court of law, so the proper protocols and language should apply.
As the court pleases. My learned friend, Advocate Dele, he avoided answering that question.
No, he might have avoided answering the question. What's your submission?
My submission is...
What is the legal point that he raised, which you want to reply to? Because if he avoided, then there's no need to reply to something he avoided.
There's no need to reply on that one, my lord, but okay. I was responding to your question.
Okay.
Yes. So that was... The second issue was actually on the issue of ouster clause. The third issue, my lord, is on the issue of reasonableness. And my learned friend correctly identifies the principles as cited in the South African constitutional case. And he says...
In the DA case?
In the DA case.
Yes.
Those principles are correct and they should be applied here.
On rationality, not reasonableness.
Rationality, my lord. Yes. He says there ought to be a connection between an objective and the reason. And we submit the proper application of that in this case would be to inquire as to the reason.
No, the reason we know is common cause. We don't even have to worry about. We know ABC1.
That is
ABC1 contains the reason. Now the issue is whether or not there's a connection or a nexus between the reason and the purpose.
As the court pleases.
The purpose being containment of COVID-19.
Yes.
That's the only issue.
Yes. And this is...
At least on the test of DA.
At the test of DA, yes, I agree. We have to identify the reason, then we look at the purpose and the objective. And the objective is actually the containment of the coronavirus.
Not frustration of Parliament.
This is what they are saying.
No, I'm saying, what do you say? They are saying the reason is ABC1.
Yes, on assumption...
The purpose is COVID-19, containment thereof. Yes. Now what do you say? Is there a disjuncture?
The next question then would be...
No, is there a disjuncture? Are you submitting that there's a disjuncture, there's no purpose?
We submitted that there was no purpose at all. The purpose was to frustrate Parliament. But assuming on assumption that the court will not find in our favor...
But once you say that, Mr. Ndebele, then you have to tell us, where do we get that on the evidence?
Because perhaps I need to add, in terms of ABC1, I don't know what it is. In terms of ABC1, we now know that the reason for prorogation is containment of COVID-19. So are you saying there's no relationship between the prorogation, which is what I understood you to be saying, that we should look at the means employed, which is the prorogation? Again, we establish that relationship between the means and the end, which is what? To contain COVID-19. So the question is whether you are saying there is no connection between the two, as I understand.
Firstly, I would submit that there is no such. The
What?
intended
There's no
purpose.
such one.
There's no connection. The intended purpose was actually to frustrate the parliament.
Hence
That
the
would be,
question, in terms of the evidence presented, is there anything pointing to that the actual reason is that the PM intended to frustrate Parliament?
we have tendered our evidence to prove to the contrary, and the court will consider it. They provided evidence to say it was corona. But let us assume it is corona, my lady and my lords. Let us assume it
We
is
don't
corona.
assume. That is what the
That's what
prime.
I'm saying.
That's what the Prime Minister says, Mr. Ndebe.
As the court
There is
pleases.
no room for assumption.
As the court pleases.
You might disagree. We understand that you might want
Then
to disagree
why-
with
this-
the reasoning.
Then the next
But
question.
the issue is not whether or not we disagree with the reasoning. The issue, the test.
Then
is
the next
whether
question
it-
would be-
Can I finish? The test is whether the reasons are legally justifiable on the authority of Miller, which you are relying on.
That's a good question. Then the next question, which was asked, and which has to be asked here, is if the reason is containment of corona, why prorogation?
You are saying we should ask that question and answer it.
Why not other means? Why prorogation?
That's why in rationality, the proposition is that, or the test is that in rationality, you don't ask the question of whether there are other better alternative means to achieve that,
I thought that
as opposed to reasonableness.
And
You understand the principles, Mr. Ndebe? There's
I
a
understand.
distinction between reasonableness and rationality. With rationality, you merely have to actually establish the nexus between the means and the purpose. Whereas with reasonableness, you might have to say, amongst the avenues open, was the decision maker reasonably in actually making the decision that he has done? Because there could have been a better reason.
As a court pleases. Then the next question, which was asked in the Miller case, was, but why did that need the prorogation for 5 weeks? And we ask here, why did that need prorogation for 3 months? We do not find any positive or any answer for that question. Because if you look at Annexure A1,
Can you tell us, Mr. Ndebele, what are you saying then on the length of the prorogation?
the length of prorogation is unreasonable, and there's no reasonable justification for
What's the
that.
test? Which test are you urging the court to adopt?
We need to refer first to Annexure A1, because that's where we can establish whether it is reasonable to have prorogation of 3 months. At paragraph 2, Roman figure 2B, the cabinet decides that the schools should be closed up to the 17th of April. Then, and the purpose of that was to contain virus.
No, let's forget about the schools. Let's concentrate on Parliament because we are debating prorogation.
No, in order to assess reasonableness of this particular Prime Minister, my lord, we need to refer to the evidence that he presented before this court.
But that's not the evidence for prorogation, you see. That cabinet decision is not evidence for prorogation. What is evidence for prorogation is ABC 1. Because that decision of cabinet does not
mention the issue.
Parliament. It was they did not talk about Parliament.
I quite agree, but it is important, my lord, to.
In any event, that decision is not even binding on Parliament. Even if it purported to do that, separation of powers, the imperatives thereof, dictate that that decision would not bind Parliament in any event.
My lord, I remember her ladyship asked this question to Mr. Taylor. Why didn't you consider this in terms of Annexure A? And I'm referring to it because it is relevant for purposes of assessing whether the 3 months is reasonable or not.
But I'm saying, Mr. Ndebele, why is it relevant?
It's because that was another mechanism, my lord, that was invented to contain virus.
But
From the same government.
But you see, the Prime Minister departed from that cabinet decision when he advised, under 83.
And no reason is given for that. For that departure, my lord.
But that's why then the case of AG versus His Majesty is dispositive of the issue. That when it comes to advising His Majesty, that's the function of the PM and the PM alone. Even cabinet cannot have a say in as to how he should go about advising His Majesty.
My lord, at the end of the day, the Prime Minister was supposed to report this matter to the Parliament and give justification. And that justification...
You are now going back to 91.3.
Yes. And that justification, my lord, and in justifying that, or giving justifications...
Is he called upon to justify to Parliament?
Or report.
Or to report, because those are two separate
reporting, my lord,
duties.
Reporting, my lord, entails justification.
No, but the draftsman of the Constitution used the word report.
Yes.
And if you look at the English dictionary, and I can assure you, the last time I looked at it was yesterday. You know, that distinction is still maintained in English. That reporting is separate from doing what you say the Prime Minister should do. That is justified.
As the court pleases. But may you allow me to may you allow me, my lord, to finish my submissions?
No, you might be reading a different English dictionary, you know, Mr. Ndebe, but I'm merely saying you should draw that distinction.
In my view, my lord, reporting to Parliament would include giving justifications why such decision was taken. It cannot just be to go to Parliament and tell them, I have taken this decision. There ought to be explanation why certain decisions were taken. Now, what I was saying, my lord...
explanation is contained in 91.3.
I did not get the question, my lord.
That explanation is contained in 91.3 as to what he has to explain.
I submit not, my lord, because...
then if it is not in 91.3, then it's irrelevant constitutionally. Because we know what 91.3 says he should go then report about.
My lord, can I finish my submissions then and the court will decide?
No. We are testing your proposition. You can't say don't test them because I want to finish. That's not the approach of counsel.
Yes.
Counsel is here to assist the court. And the court is entitled to put questions to counsel. Let me test the propositions that counsel is advancing.
Let me make my final submissions over this particular issue. Though I don't agree with the court, but my submission was...
If you don't agree, you are in trouble. If you don't agree with the court, then you are in trouble.
My
And
first
I thought if the court takes a position, yours is merely to say as the court pleases. Not that I disagree with the court. I don't know what advocacy this would be where counsel would be saying I disagree with the court. Because once you disagree, you stop submitting because you'll be in trouble.
May I put it this way, my lord?
Yeah.
Yes. The first submission that I made in a form of question to be answered was, why prorogation? Then I went further to say, now, if it is prorogation, why 30 days? Why 3 months?
We have gone through that.
We have gone through that.
Okay, what is the last point that you wanted to
And
make?
I was saying 30 days was unreasonable under the circumstances,
We have gone through that.
as the court pleases. Okay. The last thing that I want to discuss, my lord, is the issue of the prayers stopped. I'll start with prayer number 3. Well, we treat that issue. And we gave evidence that justifies the granting of prayer 3.
Where is the link, the constitutional basis for that prayer?
That declaration
Yes, where do we find it in the Constitution?
that the court can declare the Prime Minister not committed.
Yes.
We're not specifically find any circumstances.
So it is not then constitutionally justiciable, isn't it? If the Constitution doesn't provide, it's not constitutionally justiciable.
Prayers of
Because the question as to whether or not the Prime Minister is fit to be a Prime Minister, that's the call of Parliament, isn't it? It's not the call of this court, that's the call of Parliament. To judge the fitness or otherwise of a Prime Minister in office.
why the Prime Minister violates the Constitution eventually, why the Prime Minister acts illegally, why does acts that violates the Constitution?
The remedy is that this court should declare them unconstitutionally invalid. Not to say he's not fit and proper, where he does what you are saying he
That
does.
is another jurisdiction of the court.
That's the only one, because the one that you are submitting that we have, you don't have any provision in the Constitution that would support it, isn't it?
Then prayer 4 was actually constitutional because to prayer 3, if the court will find prayer 3 tenable, then prayer 4 is constitutional.
In fact, 87, during your summit, we told you that 87 answers that question. Your remedy lies somewhere, not here.
That's the court basis.
If you want the Prime Minister to be dismissed,
Otherwise,
87 tells you where you should go to. It doesn't say you should come here.
It's a political question, not justiciable before this court.
the rest of reliefs will be dealt with by my
Thank you. Yes, Mr. Puti.
My Lord, I previously argued that
No, Mr. Puti, you answer the legal issues that are raised by your opponent. You don't reiterate what you argued. What are the legal issues that you want to respond to, reply to?
as a court basis.
Yes.
My Lord, my senior colleague raised the point
Yes.
that it is only parliamentarians who have the local tenure to prosecute the claims sketched in our notice of motion.
Yes.
and he made a half-hearted concession that political parties have a right to litigate the issues.
No, you didn't understand him. He said political parties must be out. Members of parliament, of course, can be in.
Thank you, my lord.
Yes.
My lord, our submission in that regard is the proposition is legally untenable. Political parties are very critical institutions to our representative democracy. We have parliamentarians because we first have political parties. And so, my lord and my lady, we submit that political parties are rightly before this Honourable Court. BNP is rightly before this Honourable Court.
But the legal issue he raises is that they have a political interest, not a legal interest, Mr. Liputi. That's what he was submitting, that, well, they do have an interest, but it's not legal, it's political.
Yes, and it's strange. It is strange what he submitted, because in the Mokhotu case, he submitted that they do have a legal interest, and the court agreed with him. The court, my lord, I repeat, agreed with him in the Mokhotu case that political parties are having not only a political interest but a legal interest to litigate issues which
Is it not
involve.
because the party in parliament?
Yes.
Is it not because of the party in parliament being given a role to actually say, this is our leader? Because here he's saying when it comes to executive powers,
Yes, my lord.
a political party doesn't have any legal interest in challenging the exercise of executive powers. So there, the case was not concerned with the exercise of executive powers. It was concerned with the decisions of the speaker when it came to the issue as to whether or not the candidate put forward by the party in parliament qualified to be a leader of opposition.
Yes, my lord. Not only a
So if you make a distinction between executive powers and parliamentary questions in parliament, where the party is assembling in parliament.
Yes, my lord. My lord, we
So
submit.
that's the context. But here, the submission is that no, when it comes to the prorogation, which is an exercise of executive power, the party has a political interest, but not legal.
Well,
What do you say about it?
that difference, my lord, we submit with the greatest respect. It is an artificial difference. Because we've got to first understand.
What is the legal interest then, Mr. Liputi?
The legal interest that arises, my lord, in the present case is predicated on the fact that the Prime Minister had prorogued Parliament, and that the prorogation of Parliament
How did it affect your clients legally?
it affects them.
Legally, how did it affect them? They are not prorogued, isn't it?
Yes, they are not prorogued.
Yes. So how are they affected legally?
I don't know how to attend to this question directly, because
They are legally prorogued.
they have a direct interest, my
No,
lord.
but I'm saying their MPs were prorogued, isn't it? But not the party itself. Hence, let's understood the concession. The concession was that, well, their MPs can sue, not them, because the party is not prorogued. It is the MPs who are prorogued, as it were. Hence,
But, my lord-
hence the the legal interest that the MPs have, not the party. The party has a political interest.
Well, I leave it to the court. I leave it to the court, my lord. We have
You can't leave it to us. You have to make a submission. What do you want us to decide, to find? How should we find it for you there?
My lord, I pray that the court should find that political parties are not only having a political interest, they are having a legal interest to litigate.
Why is it?
issues.
Define this legal interest, Mr. Putin, of the political parties. Just define it so that we can understand where you are coming from.
Thank you, my lord. My lords, I don't need to define it. I need to refer the court to
No, but I'm saying you should define it now. You are referring me to somewhere.
Section 87 of our Constitution. Section 87(2).
It deals with appointment of the Prime Minister on the advice of the Council of State.
This appointment of the Prime Minister is being...
On the advice of the Council of State, not at the behest of political parties.
But we get at the Prime Minister, my lord, at the end of the day, because
But the Constitution doesn't talk
voted
about
into
what
power.
you created, Mr. Leputi. The Constitution really says when it comes to the appointment, the Council of State will advise His Majesty. And it's irrelevant and inconsequential which party there is. What matters is the judgment of the Council of State in the matter.
I do agree, my lord.
If you agree, then on what basis are you relying on that section?
I agree to the extent that the Council of State advises His Majesty based on the numerical strength of political party voting lines. The Council of State cannot just advise the king on the appointment of the Prime Minister without the benefit.
No, on the votes of members of parliament, not parties, Mr. Leputi. On the floor of the House, when members vote, how many MPs support the candidate? You are not going to see your clients participating in that vote. Your clients don't participate in that vote. It's MPs who took an oath in parliament, isn't it?
Perhaps.
In other words, you have political parties, once the elections are over,
Yes, my lord.
they don't enter parliament, as it were. It's only those candidates who have voted under the banner of those parties who enter parliament. And 87 says, well, let them vote now. They don't necessarily vote according to party lines. That might be, but what is important there is the majority. What do the majority say? And then they give that to the Council of State. So when you say the Prime Minister,
Yes, my lord.
is dismissible, which is what you are suggesting, isn't it?
Yes, my lord. He is.
Pursuant to 87.
Yes.
Then that function to dismiss the Prime Minister is a political process. It's not a judicial process.
Mr. Ndebele is going to provide a book here by a well-renowned professor in a progressive democracy.
And which is that progressive democracy? Tell us, which is that democracy which is more progressive than ours? Ours is so progressive, that's why MPs are suing the Prime Minister. They are challenging, it's so progressive, they are challenging this Prime Minister. Shouldn't we welcome that?
Well, yes, my lord.
Yeah.
Yes.
So which is that jurisdiction which you say is more progressive than ours?
It's British. She's actually...
Or is the Miller...
It is the one...
The home of Miller.
Yes, it informed the decision in the Miller. So the Prime Minister stands dismissible.
In Britain, is he dismissed by the court? And if it is so, can you give us an authority of a British court which has dismissed the Prime Minister?
Well, my Lord, Mr. Ndebele has said the book the court will have ample time to go through what the
You have read
says.
the book. Does it say anywhere that a court of law dismissed the Prime Minister? You have read that book.
There is a concept, my Lord, of an irresponsible Prime Minister. And if the court will have time to understand that concept, yes, we submit.
That's a political concept. It's like saying a Prime Minister is a constitutional delinquent. Those are political terms. They are not legal terms. Across the border, I've heard something like a constitutional delinquent, which is akin to an irresponsible Prime Minister, I suppose, Mr. Liputi. But if the Prime Minister is irresponsible, those who actually chose him should actually take action. This court doesn't choose Prime Ministers. Therefore, it cannot dismiss them.
But
The principle is that the one who hires has also the powers to fire in terms of the Interpretation Act, isn't it?
I've referred to that in my head.
Then if it is so, who hired the Prime Minister?
He is hired by His Majesty the King.
Then who should fire the Prime Minister?
His Majesty, if the Prime Minister is proved to be irresponsible.
Not this court, isn't it?
But this court can give a mandamus.
And if the king doesn't obey, are you going to say citing the king for contempt?
Well, my Lord,
That the king should go to jail for not obeying this court's order. A coercive order. Remember, mandamus is a coercive order.
His Lordship is right.
Yeah, if I'm right, then are you going to come back and say His Majesty should be sent to prison for refusing to fire the Prime Minister?
Well, my Lord, allow me to wrap up my...
But you don't answer the question. You want to wrap up here. So should I assume that you can't answer that?
Well, the court will form its own opinion after reading the book from the professor.
No, I want a case law, not the views of a professor who conjures up a concept of irresponsible Prime Minister. He might be irresponsible, I'm not even there. But I'm saying if he's irresponsible, that's not a judicial call. It's a political call, isn't it?
Okay,
me.
allow me to concede, my Lord, thank you.
You are conceding?
Yeah, I'm conceding.
Thank you.
My Lord, their Lordships and my Lady would recall that we made a submission that this prorogation of Parliament had been conceived and founded in deceit to the office of His Majesty.
Are you answering any point raised by Mr. Taylor in that?
Yes, yes, my Lord, I do.
What point? Tell me which point he raised. You shouldn't reiterate what you said in your address. You are now replying.
Correct, my Lord.
What point are you replying?
They are making a point that there were jurisdictional facts for invoking Section 91(3). And my Lord, the point we made earlier, with the greatest respect, was...
No, answer, not the point you made earlier. Answer that. Do you have a problem with that proposition?
Yes, we have a problem.
What is the problem?
The problem, my Lord, is that a meeting occurred before His Majesty. An agenda was placed before him for prorogation. Parties discussed it. It is common
You know
cause.
there's a dispute of fact when it comes to the sequencing of facts in that regard. There's a dispute. It's not common cause.
This dispute, my Lord, is not the genuine dispute, if I may
No, but
submit.
answer the legal points, not the question of these factual disputes, Mr. Liputi. You are on reply now. You are not on the main.
My Lord,
What was the legal issue that you are concerned about?
the legal issue we're concerned about is that His Majesty never refused to sign for the prorogation.
Is that a legal question or a factual question?
It's both.
It can't be both.
It implicates.
It can't be a horse and a mule at the same time.
Okay, allow me to take it that it was a factual issue, my lord.
If it's a factual issue, you can't reply to it now.
It implicates.
You only reply to legal issues that are raised. Because we don't want to repeat the facts.
Well, I don't know how
And
to
I should
attend
say
to this
Mr.
anymore.
Putin, that it pains this court to be reiterating what counsel should have learned either at law school or during pupillage.
Yes, my lord.
That in a court of law, you only reply to legal points. You don't reply to factual matters.
Yeah, no. My lords, we've made a point in our heads of arguments. We've
You
said.
might have made the point, Mr. Put. The issue is there anything that was said by Mr. Tele as a legal issue which you feel you want to reply to? Not to repeat your submissions, because this might also have a bearing on costs, Mr. Putin, later on. It might also have a bearing on costs.
My lord,
If you keep on repeating an argument,
my lord, I'm just wondering how the court is going to resolve the issue that the meeting before His Majesty was discontinued on the understanding that
We're not concerned with the state of emergency.